Council, one item that does not a presentation of sorts that what we have on our agenda. Yeah, it was almost, yeah. We're going to now hear from the County Attorney, Mr. Mike Pullen. Mr. Pullen is going to give Council a brief update on the response to the ACLU NAACP complaint of the open meetings violation, as been well documented in the paper. Mr. Pullen has prepared his address to the Open Meetings Compliance Board and is now to give Council an update on that. Mr. Pullen?
Thank you, Mr. Pack. I'll just start with a brief recap. The NAACP had requested the Council to remove the Confederate statute from the courthouse lawn and replace it with a joint Union Confederate statute, and Council decided to leave the statute in place and to consider proposals for a new statute that would commemorate the soldiers from Talbot County who fought for the Union. And the ACLU and the NAACP elected to file a complaint against the county suggesting that the county had violated the Open Meetings Act. And now the county has responded to that complaint and explained to the Open Meetings Act Compliance Board why the county believes that it fully complied with the act. So the county believes that there's been no violation of the act because the county owns the courthouse, the existing statute, and manages and controls the courthouse grounds. And control of county-owned property is an administrative function that is exempt from the act, and consequently there's been no violation. Now the Open Meetings Act applies in some but not all circumstances. For example, it applies when a public body performs an advisory function or a quasi-legislative function, but it does not apply when a public body performs an administrative function. So a public body performs an advisory function when it studies or makes policy recommendations to another public official or body. And so in making its decision regarding the statute, the council was not giving advice or making recommendations to anyone. It was exercising its own decision-making authority. And so it wasn't performing an advisory function under the Act. And so a quasi-legislative function is when a public body creates or amends a rule or regulation that has the force of law. And so existing law, what the council was doing was applying existing law, which gives the council control over county-owned property and also an existing county policy that applies to monuments and statutes on the courthouse ground. So rather than creating a new rule or policy, the council was applying an existing law, an existing policy, and therefore was not engaged in a quasi-legislative function. Now, as I mentioned, the Act does not apply to administrative functions, and a public body performs an administrative function, as I just explained, is when it applies an existing policy, rule, or law. And as I mentioned, state law gives the county council control over county-owned property. Management and control of a county courthouse has been a well-recognized executive or administrative function of county government for well over 100 years. And as I mentioned, in addition to applying that state law, the council was applying a policy that the previous council had adopted in March of 2004 concerning monuments and statutes on the courthouse lawn. So in the county's view, the council was performing an administrative function that is exempt from the Act, which means that there was no violation. And so that's just a brief overview. The council or the county has filed a fairly detailed answer with the Open Meetings Act Compliance Board, and which lays that out in a lot more detail. So having said that, I know the council looks forward to working collaboratively with the NAACP concerning this or any other important issues that affect the community, and with that, I'd be happy to respond to any questions.
We certainly do going forward. Any other community activity that we can jointly work with NAACP or any other group. This council has always been very open to that. So you're absolutely correct. We are
So-
open to continue that relationship.
So I know that ACLU and the NAACP submitted their written charge against this council, and you've, in essence, responded with a written defense of the council. Is there another round of written opinion? Does it go to the board of the Open Meetings Compliance Board now for a decision?
Yes.
And what is the timing on this?
Typically, they're fairly prompt. Generally, it's about 30 days, but it's up to them. It depends on their workload, other commitments, things like that.
So now that we've submitted our defense, I guess, it's a 30-day window until we hear back from them as to a decision.
I think that's generally correct. I mean, it could be longer.
Okay, thank you.
Anyone else? Mr. Pullen, your release, has it been provided to the press as of yet?
We sent a copy of our response over to the press this afternoon,
Okay.
and I can provide them with a brief synopsis of the major points.
So I know we have representatives from the Star Democrat here, so they should have their copy at their location for tomorrow's paper.
Right.
Okay. Anything further?
You sent the full detailed response or the Reader's Digest version to them?
I sent the full detailed response, but I'm going to provide a sort of the Reader's Digest version as well.
Okay, Mr. Pullen, thank you very much.